Hi, folks. I'm Greg McLawsen, the Affidavit of Support lawyer. I've spent the past 10 years representing green card holders in federal litigation to enforce the USCIS Form I-864 Affidavit of Support. Something I hear, I don't want to exaggerate, but really just about on a daily basis is from somebody who's in a divorce. This is a green card holder who calls us up and says, help, my divorce attorney has never even heard of the Affidavit of Support. What do I do? Well, here's some thoughts. So, first of all, the Affidavit of Support is an unusual area of the law. It comes out of immigration law. This is section 8 USC 1183A is the portion of the Immigration and Nationality Act that creates the Affidavit of Support. And not surprisingly, your family law attorney might not be familiar with that or any other component of U.S. immigration law. Let's just leave aside, whether that's something that the family law attorneys really ought to be getting their heads around or not. But let's just accept the fact that there are a lot of family law attorneys out there who just don't have any awareness of the Affidavit of Support. So what do you do? Well, there are basically a couple options. Number one, you could, as the green card holder with a case under the Affidavit of Support, say, well, forget about family law court when it comes to my Affidavit of Support claim. What I'm going to do instead is take that claim to federal court. And as somebody who does tons and tons of these cases, that's where we usually file Affidavit of Support claims. This is a claim that arises under federal law. We've had very good outcomes in federal court, and that's our home turf. So other things being equal, that federal court is where I would want to be to assert an Affidavit of Support claim. Now, there are procedural reasons that becomes more complicated when there's a divorce going on. Now, I'm going to be working on a brief later today on exactly this issue. One of the concerns that federal courts have is that they don't want to step on the toes of state judges, especially in the arena of family law. So if you have two parties going through a divorce, federal judges want to be real careful that they aren't doing anything that would interfere with the ongoing family law case. So you've got to be real sure that you are not asserting the affidavit claim in both courts. What you don't want to do is mention it in the family law case ineffectively and then go into federal court, because then the defendant is going to argue to the judge, hey, look, judge, you in federal court can't hear this claim because it's already at issue in the family law case. So you can certainly bring a concurrent federal claim. We've done that. We've had federal judges rule on the issue and say, we understand this is a separate issue. Yes, it involves the same parties, but it can go on concurrently even while the divorce is proceeding. But at the very least, you want to be doing that carefully. So option number one is you just accept the fact that divorce counsel is not familiar with the Affidavit of Support claim, and you just shift your forum, shift the place where you are asserting your claim under the affidavit and make that in federal court. That's option number one. Option number two is to bring in an outside expert into the family case to help your family law attorney with the Affidavit of Support claim. So in addition to litigating federal lawsuits, one of the things I do is serve as a consulting expert in family law cases. Because again, this family law attorney, let's just say they've never even encountered the Affidavit of Support. So I'll serve as an expert, consulting expert and an expert witness in court if needed to help that attorney get their arms around the law on Affidavit of Support enforcement and make sure that the claim is being asserted in an effective way in family law court. And this can actually be a very effective way of getting the claim in front of a judge quickly and efficiently. Historically, I've been real concerned about the outcomes that I've seen in family courts. There are a whole bunch of appellate cases where a family law judge will acknowledge the enforceability of an Affidavit of Support, but will then arbitrarily limit the duration of support that's paid under the affidavit. So when I see decisions like that, it makes me really concerned about going to state court when I know that federal court is an option. But the upside to family law cases is that the cycle time, the time at which decisions are turned over, tends to be much faster. So if somebody is already in a divorce, the case is already open, you've already got a judge assigned, it can be a much quicker path to getting a case resolution than starting a separate federal action. So especially if I think that family law counsel is otherwise doing a great job in the case, it can be a good option for a client to bring in an outside expert, and then things are already underway in family law court. You just add the affidavit of support claim on top of this. Now, in either situation, pretty much by definition, you are talking about somebody. This is the green card holder, the immigrant who is sponsored by the affidavit of support. This is somebody who is low resources. To have a claim under the affidavit, your income has to be under 125% of the poverty guideline. So this is somebody who's very low resources. That's okay when it comes to bringing in an attorney or expert on the affidavit claim, because there is a fee shifting provision in the statute. What that means is that when you successfully assert your affidavit of support claim, the defendant, the sponsor, is responsible for paying your attorney fees. So both in the context of the federal litigation that I do, and also when I'm serving as a consulting expert in family law cases, those fees are paid by the defendant. So my client doesn't have to pay me to go to federal court. They don't have to pay out of pocket for me to be a consulting expert in the family case. All of that is paid eventually by the affidavit of support sponsor. So that can be a very effective way as the sponsored immigrant to bring in somebody with a fair amount of experience doing these cases, when you otherwise certainly wouldn't be wanting to pay, thousands of dollars in a retainer to bring in an experienced attorney. So two options there. If your family law attorney isn't experienced with the affidavit of support, option one, shift strategies when it comes to the affidavits of support part of your claim. Take that to federal court. That's option number one, go to federal court. Option number two is try to bring in an outside expert to help specifically with the affidavit of support claim while doing that in your divorce proceeding. Hope that's helpful. If you have questions about either any of this that I've raised, feel free to jump into the comments. If you would like an individualized case assessment, you're welcome to reach out to me. I do video consultations all across the United States. And if you're a family law attorney, happy to talk to you at no cost about an affidavit of support claim that you may have come across in your work. Hope this is helpful, and have a lovely weekend, everybody.